Some may remember Bill's dad, Howard Samuels, who was a great champion of constitutional reform in New York. So there's a family tradition involved. I want to invite I want to thank Bill, and I want to invite the next panel to the front of the room. Peter Gailey, Richard Rifkin, Robert Batson, and Bruce Giori.
Richard. Hi, Peter Gailey. How are you? Good to see you.
The task of this panel is to talk about pending actions and recent debates. The two pending actions we mentioned had to do with the gambling, proposal on gambling and the proposal on redistricting we just heard a little bit about. I know that I have some points of view about the gambling, about both of these that may come up in the next panel as well. Peter.
Thank you, Jerry.
Our procedure, what?
Peter's a great friend of mine.
Oh, right.
Extraordinarily accomplished scholar.
Thank you. Will you hear me? Oh, I don't have this. You will hear me. Our procedure this morning will be fairly simple. I'm going to exercise the panelist leader prerogative not to take any positions on the issues. I'm going to do a framing for the context for the speakers that are going to come. We'll take roughly 50 minutes all told for the four of us. That'll leave a good 30, 40 minutes for interaction between the panelist and the audience and the panelist, and that's how we will proceed. So let me start with my opening remarks. Maybe I'll come to the dais only because I need a dais to support my notes. In the Republic, Plato is pressed to answer the question as to how his republic could be realized when none of the inhabitants had been subjected to the rigorous education necessary to create the citizens who would constitute this new republic. In response to that pressing or pushing by his questioners, he makes the startling statement that all children over 10 must be sent out of the city, wiping the slate clean. Now, as an aside, I think there's a deeper issue involved in everything we're about here in wanting to change the New York State Constitution. Plato's point was, if you don't get people at the very earliest age, if you don't sing them the right songs, the right laws won't appear. And so what Chris and I and others have done, attempted to do with the New York State Bar Association and the wonderful help of Eileen Girish, is to begin to develop lesson plans to encourage the teaching of the New York Constitution in the schools. We don't do it. And if we don't prepare the background and knowledge for those students who come up, when they hear about these issues, it's in a completely blank context. They have no way of understanding what's involved. So we think that would be a significant measure to take. Unfortunately, looking at the revised standards that are coming out now from the Education Department, the New York Constitution, Eileen tells me, is going to be relegated to the 4th grade. You can't do anything in the 4th grade with the New York Constitution. You can sing songs, but you can't talk about the New York Constitution. So we're a little discouraged about that, but we're continuing to produce these lesson plans and hope there'll be different ways of getting out to the social studies teachers in this state information on how to do this in an effective and meaningful way. The dilemma of not having a clean slate, of having to begin, not at the beginning, but in the middle of things, so to speak, and thus not having citizens and civic virtue, those things which we both necessary and the result of this Constitution, has bedeviled thinkers from Plato through Machiavelli. Coming down to earth, perhaps too quickly, it also bedeviled the writers of the latest edition of the Model State Constitution. They introduced the model with this disclaimer. Strictly speaking, there is no such thing as a model state constitution because there is no model state. And such a state would not need a constitution anyway. So back to Plato. Just short of this utopia would be a state in which all citizens are active and responsible, and in which only an extremely short document expressing basic principles of Republican government and delineating its essential features, 3 branches of government. But then the model state constitution writers go on to say, what we really need to inaugurate Republican government is to establish a representative legislature which may then exercise the constituent functions with respect to all the rest of the government. Now, such a reductio ad absurdum was expressed, believe it or not, and endorsed by no less a personage than Arthur Sutherland back in the 60s. Arthur Sutherland, I think from New Jersey, also a jurist on the New Jersey Supreme Court, I believe, also an academic of sorts, I believe. Here's what he said. It's a remarkable statement. A logically complete constitution could be written by describing the organization and selection of the legislature and conferring on it all the powers of the state. All the rest of the state's governmental mechanisms could conceivably be supplied by ordinary statutes instead of constitutional laws. And accordingly, the effect of the rest of the Constitution is to fetter the legislature. If you take to conclusion, that's what you end up with. That's really all you need. Well, since states already have power, unlike the federal government, all state constitutions in their nature are directive insofar as they mandate certain functions or duties to the legislature, and confining or limiting what otherwise would be unlimited governmental authority. In spite of these differences, the National Municipal League did have a model. It was the nation's founding document, a document they described as one of simplicity and clarity. But in almost biblical terms, the model state constitution writer said, we lost our way somewhere along the path to justice. And the loss of way, or the fruits in this case of the tree, consisted of, quote, unclear thinking and bungling workmanship, over-elaboration of checks and balances, built-in weaknesses of all the branches of the government, proliferation of thou shalt nots, statutory declarations of public policy in the guise of constitutional provisions. So what they recommended when constructing or revising constitutions, the task which in general we're about here today, was to conduct, quote, a hard-headed review of all except the clearly basic provisions to determine whether or not they meet present or future needs. Again, this idea of we could just get almost everything out of the Constitution but the basics and let it go from there. But we're back to the dilemma of founders, aren't we? There is a history which constitutes our constitutional tradition, our political practices. There's an institutional memory that cannot simply be erased, wiped clean. We cannot wipe the slate clean, and so change must perforce take place within the limits and possibilities set by those conditions. And you see the dilemma expressed, I think, in what we're going to be dealing with in this first panel. Effective government advocates see problems. They create agendas based on those problems and propose solutions. The Brennan Center, Common Cause Citizens Union, of course, the Committee for Effective Government Commission, Bill Samuels and Jerry Benjamin's project. Power holders have their own agendas and their own needs. These agendas and needs are dictated by a range of factors that often have little to do with the goals and modus operandi of the advocates of more effective government. No wonder Plato gave up the game when he made the startling admission in the Republic that the only way a just regime could ever come into existence would be either by luck, fortuna in Machiavelli's terms, or divine intervention. Do we have either one of those with Andrew Cuomo? The question of what should be in a constitution is another way of asking what a constitution would look like if we were starting on a clean slate. But of course, we start with a mixture of reform impulses, historical necessity, ideas, economic interests, political configurations, and so forth. We have, on the one hand, then, to start this conference, some worthy and thoughtful proposals for constitutional change coming from these reform organizations, clearly worthy of consideration. And we have three proposals emanating from power holders that are making their way through the political process. On this panel, we will focus on the changes brought to us courtesy of the governor and the state legislature. I've always thought that the word reform kind of begs the question. I wrote a little paper once, which I didn't publish, was when is constitutional change constitutional reform? I mean, every change is not reform, so how do you determine ahead of time? Well, we want to reform the Constitution. Well, why do we assume that's a reform? It may be changing it, it may not be reforming it. There's that kind of conflation of the two terms, which has always troubled me. So are these proposals then, we have to ask this morning, are these proposals worthy of adoption? And even if they are worthy of adoption, do they belong in the Constitution? With us today are three individuals who have an interest in and some expertise on these proposals. Their bios are in the biography or the little brochure, so I won't waste the time of the convention repeating them. And we'll start with, I think, I did agree. Did I agree to a start? Why don't we start with you, Richard, with the judicial? Yes, Richard.
Okay. Well, thank you very much, Peter. Good morning. I guess Peter decided to start with me because nobody is awake yet, because we're going to talk about the judiciary article of the Constitution, and as soon as you hear judiciary article, everybody sort of goes to sleep. But let me say the judiciary article and the whole judicial branch of government is absolutely critical and fundamental to the nature of our government. And in fact, I was just down yesterday in Washington and lobbying Congress on funding for the federal court system, given the fact that we face sequestration there, and talking all about the importance of the court system. So with that little introduction about where we're headed, let me talk about the constitutional amendment that has received first passage. It certainly doesn't have the dramatic effects of either reapportionment, which Bruce is going to talk about, or casinos, which Bob's going to talk about. It deals with the age of judges. And let me first open by telling you what's in the amendment. One of the concerns we've had in the state is that judges under the Constitution are forced to retire at a certain age. And in fact, our lunch speaker is one of the judges who's been the victim of that provision, because he was forced to leave the Court of Appeals, as, by the way, was Chief Judge Kaye and Judge Howard Levine. All three of them were superb judges who simply had to leave at a time when they were certainly functioning effectively because of the mandatory age requirement. So what does this constitutional amendment do? It does two things. One, currently for the Court of Appeals, and only for the Court of Appeals, right now, judges are required to retire at age 70. It moves it up to 80. But it says that no judge may be appointed or reappointed after reaching the age of 70. So what does this mean? It means that if you have a judge on the court and the judge's term expires when the judge is 68 years of age, to use an example, that judge can be reappointed and continue to serve until he or she reaches the age of 80. However, if the judge's term expires when the judge is 72, that judge is not then eligible for reappointment and therefore cannot serve until 80. That's what it says. Whether it makes sense or not, I leave to you. I certainly have my doubts about that, but that's what. The other piece of this constitutional amendment is really very simple. Judges of the Supreme Court, our Court of General Jurisdiction, now have to retire at the age of 70, but they can be certified to continue to serve until the age of 76. This amendment would allow them to continue to serve be certified until the age of 80. So in other words, they can get 4 additional years of certification. That's it. There have been much more substantial proposals that have been proposed. This very small, limited proposal is the one that has received first passage. I submit this is hardly earth-shaking and raises the question of why, on an issue like this, should we require a vote of the populace of the state of New York? Is this really something that is so fundamental that it requires the people to cast their judgment about this? I think not. And this is the problem with the entire judiciary article of the Constitution, Article 6. For example, the state constitution, judiciary article, has 37 sections. The federal constitution, in essence, has 2. It's got 3, but the third one deals with treason, so that doesn't count. It's really got 2 provisions. Do we need all this? And I submit that the Constitution hamstrings the courts in a number of different ways, and if I can give you just a couple of examples. Section 6D of Article 6 limits the number of Supreme Court judges in any judicial district to, in essence, 1 for every 50,000 of population. It's not exact, but that's fundamentally what it is. What it means is the legislature cannot create additional judgeships where you've reached the limit, and we have in many judicial districts. So no matter what the workload of the court, no matter what population shifts we've seen since 1938, we're left with this 1 for every 50,000. And to tell you how absurd it's become, the legislature has figured out a workaround. There's the Court of Claims. Court of Claims hears cases against the state of New York. There's no limit on the number of Court of Claims judges. So and Section 26 of Article 6 allows Court of Claims judges to sit in Supreme Court on a temporary assignment. The concept was to help out if there were a temporary need in the Supreme Court. Well, what we have done in order to get around a constitutional provision, the legislature has created additional Court of Claims judges. And you now have what are called A judges and B judges. The A judges are the judges who do the traditional work of the Court of Claims. They hear cases against the state of New York. The B judges have never heard a case against the state of New York in their entire careers. They're fundamentally criminal court judges who sit in criminal term in Supreme Court. They are Court of Claims judges. They are assigned to Supreme Court. They're intended to be assigned to Supreme Court. The judges who have been appointed have criminal backgrounds because they're going to sit in the criminal part in Supreme Court. Court of Claims has no criminal jurisdiction whatsoever.
Criminal law background.
Well, criminal law background. Correct. Maybe you can argue that maybe some of them have criminal. And so you have an absurd system where the Constitution says you can't have additional Supreme Court judges. So the legislature says, well, we can't do Supreme Court judges, so we'll have Court of Claims judges and we'll assign them to Supreme Court. And what's also done, by the way, is judges are taken from other courts and they're made acting Supreme Court judges. Judge who I know has been an acting Court of Claims judge, acting Supreme Court judge for better than 20 years. He's getting close to the age of 70. Court of Claims judges can't be certified. So what he just did last year is run for Supreme Court, was successful, and now he can be certified to age 76. This is what the state constitution is doing to the judiciary. They ought to have a provision which allows the legislature to deal with the problems of the courts and adjust the problems of the courts. Let me quickly give you a couple of other examples. Court of Appeals, our highest court, the legislature has defined the jurisdiction of the Court of Appeals in 9 highly technical subdivisions, most of which are incomprehensible. And the legislature can only remove certain items of the jurisdiction of the Court of Appeals, but not others. Why shouldn't the legislature be able to fix the jurisdiction of the Court of Appeals so that the court's jurisdiction can meet the needs of the current day. Or you take the jurisdiction of the lower courts. The Constitution sets the jurisdiction of the lower courts on a monetary basis. County court, $25,000, New York City Civil Court, $25,000, district courts, $15,000, meaning they can hear cases up to that amount. Is that a fundamental policy of the state of New York as to whether or not a district court has jurisdiction of $10,000 or $20,000 or $30,000? Is that so fundamental that the entire populace has to vote on that? In fact, it has. The populace has raised the jurisdiction out of desperate necessity because, after all, we have inflation, the value of money changes, and what was $10,000 jurisdiction in 1938 certainly is not what it is today. So if you limit it to $10,000, you're really limiting the number of cases. Unless anybody thinks there's an argument that there's really some fundamental issue here, the Supreme Court, our court of general jurisdiction, has the power to send down to a lower court any case brought in Supreme Court without monetary limitation. So if somebody brings a case in Supreme Court and it's worth, say, $250,000, the Supreme Court has the right to send it down to the New York City Civil Court and say, you hear it, despite the fact that you've got a $25,000 monetary limit. So, again, there's no fundamental issue here. And this just ties the hands of the courts and the judiciary. And in closing, to come back to the amendment, let me just say that I think this amendment, raising the age of judges, is a perfect example of why fundamentally we've got to scrap the judiciary article and start from scratch. We need a constitution that allows the courts to function, that gives flexibility to the legislature to define the courts so that it can meet the modern and changing needs of the courts, and remove the provisions that hamstring both the legislature and the judiciary from really making our courts an efficient system.
Richard, thank you. Quick question for the audience. If you were advising us as citizens, we're going to come to vote on this thing, this particular amendment, up or down, what's your recommendation?
Well, my first answer, it probably doesn't make much difference because it's so small. It does next to nothing. But if I were going to vote on it, I believe that the idea of setting an artificial age of 70 in this day and age when people, I'm over 70, so I guess I have a biased view, but when people reach the age of 70, in today's world, many people function very well. And the idea of forcing people who are functioning well and serving well to leave the bench just because they've reached an age is totally artificial. And so to the extent that this gives a little bit more flexibility, I would urge a yes vote on it.
Thank you. Our next speaker is Robert Batson, and you're going to speak, Robert, on the gambling amendment, is that correct?
Yes, I am.
Yes, all right. Please.
Okay, thank you. Yeah, New York's public policy on gambling is spelled out in Article 1, Section 9 of the Constitution. Article 1, Section 9, it's in the Bill of Rights section of the Constitution, and it's in a provision of the Bill of Rights that addresses the right to assemble and to petition the government. I guess the first question is, why is it in the Bill of Rights? It's really, what it does is the gambling provisions limit the legislature, which makes me think it more logically would be placed in Article 3 of the Constitution. But more fundamentally, I guess, ask the question is, why is gambling a constitutional issue? Like, I've looked around at some of the other state constitutions, and most states do have a provision on gambling in their constitution, but this isn't something unusual. And looking at the history of it, that the provision evolved from a prohibition on lotteries that first appeared during the 19th century. Back in the 18th and 19th century, lotteries were the fundamental method of financing public works. That was before the day of the municipal bond or any other kind of bonding. You didn't have the traditional lending. So what they did was they used lotteries to fund public works. The legislature kept trying to limit lotteries, and there's a lot of abuse in the system, and ultimately the Constitution was amended to put a ban on lotteries. Well, at the time of the 1894 Constitutional Convention, they're concerned that other types of gambling were going on in the state beyond lotteries, what they call pool selling and betting on horse races. And in 1894, the Constitution was amended to provide an outright ban on gambling. Now, this, of course, limited the legislature from authorizing gambling in any way. What happened, the legislature did get around this. One way they did this was they basically decriminalized violations of gambling. For instance, they made betting on horse races pretty much just a civil offense. So they've essentially decriminalized it. And the horse racing industry was fairly significant in the state. And in 1939, the state constitution was amended, Article 1, Section 9 was amended to authorize parimutuel betting on horse races. Parimutuel betting on horse races, that's where there's a pot of money and the prizes are paid out of that pot of money. It's unlike a casino where a casino could conceivably lose money. But then in 1957, there was another amendment that authorized bingo and lotto on a local option basis for certain not-for-profit organizations. This was enacted a lot of interest in churches and other not-for-profits, volunteer fire departments, of using bingo to get funding. And the state legislature was concerned that churches that were offering bingo were essentially engaged in what was a criminal enterprise, so the Constitution was amended to set up a process where these not-for-profits could conduct bingo and lotto-type games. These are, if you go to a church or fire department bingo, they have what they call bell jars. They're a little piece of paper where you pull tabs, and if you get the right combination of tabs, you win a prize. Then in 1975, the Constitution was amended again to authorize what are commonly called Las Vegas nights, also on a local option basis to not-for-profit organizations. And this is where the not-for-profit can bring in things like roulette wheels, they have blackjack, craps games, all the common table games in a casino. Now, the main thing is that these provisions authorizing bingo and the Las Vegas nights have limitations on the size of prizes and the total aggregate prizes allowed. So that prevents them becoming like full-scale casinos. In 1984, the Constitution was amended to give the legislature the power to authorize larger single and aggregate prizes than stated in the Constitution. So basically they're saying, we have these limits in the Constitution, but they don't apply if the legislature wants to make them higher. So in effect, it authorized the legislature to amend the Constitution on a case-by-case basis. Another significant change was in 1966, the Constitution was amended to authorize the state to operate a lottery. Now, certain developments have led to a rethinking of gambling restrictions still in place. Indian gaming has flourished as a result of a determination by the U.S. Supreme Court that a state's regulatory authority does not extend to gambling conducted by a tribe on its own reservation. In the 1987 Cabazon decision, the Supreme Court looked at provisions in the California Constitution that are similar to those in the New York Constitution dealing with bingo and state lotteries. The Supreme Court stated that in light of the fact that California permits a substantial amount of gambling activity, including bingo, and actually promotes gambling through a state lottery, we must conclude that California regulates rather than prohibits gambling in general and bingo in particular. The effect of this decision was that California could not penalize a tribe that conducted bingo games that offered prizes larger than what was allowed by California's statutory scheme. While the states were subsequently granted some role in overseeing some types of Indian gaming by the Indian Gaming Regulatory Act, gaming on reservations has become a major enterprise around the United States. At present, there are 5 casinos in New York State that operate under the Indian Gaming Regulatory Act. In addition, the state has authorized a number of racetracks to operate video lottery terminals in so-called racinos. Now, interestingly, several of these racinos call themselves casinos, and they identify the video lottery terminals as slot machines. Now, which kind of got a quote from Judge Rosenblatt, who's going to be with us later today, in the case of Saratoga County Chamber of Commerce versus Pataki from 2003, the Court of Appeals via Judge Rosenblatt wrote that the people of New York State have decided in New York's Constitution to prohibit commercial gambling. Well, it seems to me that there's a lot of commercial gambling going on in New York State between the racing industry and the racinos as well as the Indian casinos, that we actually do have a lot of commercial gambling going on in the state. Now, Governor Cuomo has proposed a constitutional amendment that received first passage by the legislature in 2012. The proposal once again amends Article 1, Section 9 to allow no more than 7 casinos as authorized and prescribed by the legislature. So the basic rule is gambling is prohibited, but there's just another exception, and that the legislature can allow up to 7 casinos, would be full-scale commercial casinos. And unlike some earlier proposals, it does not limit where the casinos may be located. And if passed by the legislature in 2013, it will be on the ballot next November. Jerry.
I read a little about this. Let me, Peter, may I just?
Yes. Sorry, Peter.
2 or 3 things to say about, is this on?
Yes.
There's 2 or 3 things to say. One, it's interesting how value gets entrenched, and then the tension between the legislature and the legislature's desire to act and the value plays out. You know, and this is a classic pattern. You know, it's constitutionally, it's evident in constitutional dynamics in virtually every article. So it's kind of exemplary. Second, the interesting thing of having a provision that has so many exceptions that the provision has no force or effect is comes to Bill's point about language in the Constitution that is at least his language, the language he objects to, has some effect. So why then you would speculate, why would the governor create another exception rather than just seek to abolish the provision? You know, and that begs for a political explanation, not a constitutional explanation. So we end up with a document that has a certain emptiness that provokes people to disrespect for the document, because it says something that apparently is not so. And then the final point is I've been intrigued by the number 7, and maybe there are people in the room who can seek me out and tell me why the governor chose 7 potential casinos rather than 5 or 9. That would be interesting to know. I have theories about that, but I think this is really a very powerful, and I think this is, I don't know if we're going to do prognostication during the day, but I think that the recent tragedies in southern New York reinforce the prospect of the passage of this provision on the basis that the money is needed. So I think that the context is very positive for this amendment, but maybe that's for another point, a discussion for another time.
Maybe it's 7, 11.
Maybe it's lucky. That's right.
Yeah. Well, it's essentially the exceptions have swallowed the rule, it seems.
Right.
Okay, thank you, Richard. Now, Bruce Jory, is that how you pronounce it?
Yes, thank you, and I'll answer anything close. It's been mispronounced quite frequently over my 58 years, but thank you. First off, just thank you for inviting me. It's an honor, and there's very little I would turn Jerry Benjamin down over. I hold him in such high professional regard and personal esteem. I was looking for a hook, Peter, and you gave it to me when you mentioned both Plato and Machiavelli. Machiavelli will come a little later, but let me start with Plato. Plato was an outstanding diagnostician, but he did not have the patience to practice the medicine of politics. But in his Republic, he gives a very fascinating allegory that will help us here. It's the allegory of the cave. You will remember that. It is that we see not the source of light, which was Plato's analogy to knowledge and truth, but we only see shadows. And therefore, the Platonic journey is to peek around the shadows and constantly search for what is the source of the light. And there's probably no topic in politics where that is more appropriate than reapportionment, or to be blunt, partisan gerrymandering. I first studied this when I did a paper on the Wells v. Rockefeller cases at Columbia, and because my late father was a friend of David Wells, I actually got to sit and spend 3 or 4 hours with David Wells, which assured me an A and taught me a lot, for which I'm grateful. But let's recognize what's in play here. And I think, quite frankly, while I come down, I think, though no one's interested in my view, where Bill comes down on substance, I think his anger towards Cuomo is somewhat misplaced, in that Cuomo has made the same exact decision that every governor before him has made, and we're talking powerful governors, whether it's Smith, whether it's Dewey, whether it's Rockefeller, whether it was Mario Cuomo, that they just weren't going to get into this with the legislature because they will fight to the death. Especially when you have, in this time, in this political era, a state senate that feels if we change campaign finance, and unless we're allowed to draw our own lines, we will lose the majority. I don't say that as an indictment. I'm not Inspector Joubert. I'm just saying that is a political truth. That is what they feel. So the governor acquiesced to that. But because he campaigned as a reformer, and I think left to his own devices would support more independent redistricting, he insisted on this cover. Now, Jerry, when he first asked me to participate here, he said, he focused me, he said, do you think it will actually pass, or will they kind of wriggle off the hook? And until I read his critique, and might I add, as I'm going into grading papers in my own course, I would hate to have Jerry Benjamin grade my paper. That was pretty rough stuff you gave there, Buster. But he persuaded me. And so I don't think they are going to get off the hook, to try to wriggle off the hook, because I think they have crafted for themselves a rather exquisite fig leaf. It has the patina of reform, but because of the even nature, they're not forced to, it's like the boards of election at either the Federal Election Commission or state, it's evenly divided. Gridlock is easily achieved, which means that it will lead them to try to find a way to come to the politics of the lowest common denominator, which means to make both the Senate majority and the Assembly majority happy with the lines, and therefore have a cover. So why should they change? Yes, I think it will pass a second time the legislature and go before the people. Now, there's only 2 people that are entitled to my partisan views: the candidates who hire me to be their consultants, and my children when I pay for dinner. So I'm going to spare you all that, since neither of you are, I'm not neither buying you dinner nor are you paying me, so I'll leave that to you. But if I were a reformer, I think I would, who really cared about independent redistricting, I think I would accept Professor Benjamin's grade and Mr. Samuel's opposition. But let's go a little deeper. Let's examine the law of unintended consequences. You know, we all think that these guys and gals who draw the lines, you know, the cartographers, although now they do it by computer, I'm just showing my age here, that they know what they're doing. But that is an extraordinarily difficult political thing to do, because you not only have to gauge correctly the first election, in this case 2012, you have to accurately gauge the trend line of political demographics and how issues interact, so that you have to be able to win the 2014, 16, 18, and 20 elections. So you have to be right for 5 consecutive elections. I hold my own political opinion pretty highly. I think I know politics pretty well over 50 years of being in it. I don't think I know enough to do that, and I'll give you a prime example. This year, look at what they did. The Republicans drew their lines in the Senate. What did they do? I advised them to create, on your daughter's show, I said if I were them, what I would do is I would befuddle the reformers and the Democrats and follow the census. I would create a minority district on Long Island. And that would functionally take a great deal of, because the census shows Long Island is now 31% minority, the aggregate of black, Hispanic, Asian, and biracial. For those of us who are over 55, think about that. If when you all got involved in politics and government, I told you Long Island would be 31% minority, you'd go, what are you smoking? Are you with Soros on the other issue, on medical marijuana, right? Big change. There's dramatic pressure on at least 4 Senate seats as a consequence of that. That's why Kemp Hannon only won by 4%, or maybe down to 3% now. That's why Martin's only won by 2%. That's why Boyle, despite running against a relatively weak candidate in Owen Johnson's old area, only won comfortably but not overwhelmingly. In Zeldin, in Suffolk, will always be under stress because of the growth of the Hispanic there. So as a consequence of putting those 4 seats in jeopardy over the next 5 cycles, they created a new seat they were assured of winning. They tapered it to Amador, because George Amador is known and popular in Amsterdam, Rotterdam, and Schenectady. Oh, but the district they created was a majority Democratic district, and in order to do it, they had to bring it down to Ulster. In the upper mid-Hudson Valley is changing dramatically politically. Franklin Roosevelt wishes he could come back and run there now, right? He could never carry Dutchess County when he ran for president. He could carry it now. So they may lose that seat, and so there are these, beware the law of unintended consequences. This is nothing new. In 1980, Tarky Lombardi went to Warren Anderson, and he said, Warren, Onondaga is starting to turn. It's becoming, you know, my district is less Republican than it once was. I'd like you to give me some of those better Republican suburbs that Marty Auer has and push Marty out towards the more rural areas. His district will be a little less Republican, but you know, the Democrats will never find somebody who can carry the rural areas until Nancy Lorraine Hoffman, in her first iteration as a Democrat, put on her boots and out-campaigned Marty Auer in the rural ends of the district and won. And then Guy Villela went to Joe Bruno and he said, you know, there's these rumors of an indictment. I'm gonna be okay. Legally I'm fine. I'm not gonna get convicted. I didn't do anything wrong. My father's a little sloppy. He's an old man. You know, don't worry. But with all the turmoil, you know, give me Eastchester. Take it away from Nick Spano. What happened? Republicans wound up losing 2 seats over that, both the Villela and the Spano seats. So beware of the law of unintended consequences. Now, a bit of historical, not trivia, but just insight into this on the Constitutional Convention. My mentor in politics was the late Alex Rose, and most kids went away to summer camp. I came up in the summer of 1967 when I was just shy of 13 to come to the Constitutional Convention and watch that. And anybody who thinks that a Constitutional Convention, I remember Earl Bridges being treated as if he was a Roman consul when he was president of the body. He was the Senate Majority Leader. And Bill is absolutely right, and his father's his late father, who was a treasurer for the state, his late father's campaign manager, Ken Auletta, wrote one of the best books on the fiscal crisis, The Streets Were Paved with Gold, and said that if those constitutional amendments had been, that if the 67 Constitution had passed, the very three provisions the bill referred to would have maybe given us a better chance of avoiding the fiscal crisis, particularly the one in regard to Medicaid. But let's remember what that Constitutional Convention foundered on. It foundered on the Blaine Amendment, which really had little to do with anything else, but it was an old battle that pitted white Catholics and liberal Jewish voters against each other over that, and the Roman Catholic Church versus the Liberal Party and the New York Times. And so the liberals, who on substance would have supported those three provisions, voted it down because the Blaine Amendment was repealed in the Constitution. Now, Machiavelli. Let's remember, Machiavelli's so misunderstood. He was far more practical than cynical, and he was writing to a Medici prince after all, so he was trying to prove persuasive, so he appeared to be more cynical than he actually was. He said a wise prince must be a lion and a fox, and I would advise the reformers to get real and to recognize their weakness. They have a tendency to be platonic and to go for the truth rather than to find a way to get voters who are very busy people to understand it. Voters are not stupid. As V.O. Key told us, they're a responsible electorate. They're just a busy electorate. And therefore, find a way to pitch the issue to them. It's not whether it's an independent commission or not. It goes to the heart of the consent of the governed. If the elections are rigged because functionally whoever gets the Democratic line or the Republican line in a given district, that most of them are going to win just by dint of that, your vote doesn't count. I posit that if that is what you lead with, you'll have a more persuasive case than if you get into these, what it should be. There's a great story about Father Hesburgh in that. As a young man, Father Hesburgh is a trained lawyer, worked on the analysis of why proportional representation should not be done in the city council. And he tells this story in a great way, reams of data and learned pieces, and he was a pretty smart guy, about why it would not make sense. And they brought it to a practical old political hand, probably a grizzled guy, looked a little like me, and he said, yep, that's all well. Why don't you just tell the people if you have proportional representation, you'll elect communists? And that's what they did. And proportional representation was thrown out. So reformers need to get real. Now, the lion and the fox was, just to conclude, a wise prince must be both a lion and a fox. A lion to scare away the wolves, and a fox to avoid the traps. Machiavelli went on to remind us, or to teach us, that if you're only a lion, and you charge ahead, you could fall into the pit and you will die of starvation. But if you're only a fox and only avoid the traps, you can be overtaken by the pack of wolves that would chase you. So a wise prince must be both a lion and a fox. So I would argue for those of you reformers who believe that Jerry and Bill are right on substance, internalize that lesson of practicality. And you have an option here. You see, they played a game with you. Turnaround is fair play. The game they played with you is, let's put this fig leaf of reform now, and it won't bother us till 2020. Well, that clobbered you guys this year because you didn't get what you wanted for this election. We have, 9 years to go before the next time? So if you persuade people this is not the way to go, and don't keep yelling at the governor, but give him a chance for redemption and change it so that if the referendum went down, I'm not advocating voting against it, that's for those of you that know, but if you persuade people, then everybody has to come back, because the governor's position is not the status quo as we knew it before continues. We need a change. Well, if the voters reject that change, you have a chance to give him that opportunity for redemption. So like Thaddeus Stevens, for those of you who've gone to see the Lincoln movie, you are prepared to let him issue the Emancipation Proclamation after Antietam in 1862 instead of 1861 upon inauguration. Get practical and figure out how to do it. But let me end with this one thing, and I went on a little too long, but I went from being a hawk on reapportionment to a dove, actually to being a meek cat, to being a hawk again. I'll tell you why. In 1982, I worked with a group that was working on a platform for state elections, and there's great power preliminarily in being the drafter of this thing, because you can sneak in things you want. And I snuck in this thing about independent redistricting. And I got slapped around so bad by everybody on that. The legislature will never buy it. That was like, whoa, I was a little bit like Mark Twain's cat. You remember Mark Twain's cat? Mark Twain's cat once jumped on a hot stove and never went near a stove, whether hot or cold again. I never touched that. And then I lobbied it for years, and so you get into like, ameliorating or accommodating yourselves to the way the legislature views it. And in fairness to them, they don't like surprises. But then I realized that the dysfunction, and now that I'm no longer lobbying and no longer practicing law and teaching and doing political consulting and nobody listens to me, I can say whatever, I can actually think what I actually see. The twin germs of dysfunction are reapportionment, partisan gerrymandering, and the current campaign finance system. Why do I say that? And let me take it out of the state so I don't turn all my old friends in the legislature against me. What's going on in Washington now? We just had an election. The people spoke. The polls are resplendently clear as to what they want in terms of a grand bargain. They don't want to eat their spinach, but they've told you what they'll like eating less, but they do want the taxes raised. So what happens? The Republicans in Congress say, no, we don't want to do that, and we don't want to do anything on taxes. And the Democrats in Congress say, we don't really want to do anything seriously on entitlement spending. Why? Because of gerrymandering, they're not worried about the consent of the governed in the general election. They're worried about preventing primaries. They're worried about watching what happened to Dick Lugar this year in Indiana and what happened to Mike Castle in Delaware 2 years ago. And Mitch McConnell is worried about a new Rand Paul beating him so he's not in the Senate. And similarly, a lot of Democrats. This is not a partisan analysis. What is the source of that? Out of 435 seats, we had probably tops 65 contested elections. Now I'll bring it back to New York, and then I will shut up. This is the danger of inviting a practicing professor. Jerry, we go on and on, as you know. When the courts drew the congressional lines, we wound up with 10 competitive races. We only thought we were going to have 8, but then the Grimm race in Staten Island and the Reed Shinagawa, I hope I'm pronouncing the gentleman's name correctly, race. We had 10 competitive races out of what, 27? Usually we have 3 to 5 competitive races. So just by having the courts draw the lines, we had double the number of competitive races in Congress. Now, if you believe with me that if you had more competitive races, what that means is people would actually be forced in general elections to campaign and find out what people want, what the general election wanted, rather than just the narrower partisan. And I think that would be a huge, huge improvement. And I would argue that the dysfunction in Albany is not ended, but merely dormant. And thank God Andrew Cuomo has been able to forge what he's forged now. But give him a chance for redemption by creating a new political reality and a new paradigm where he will then react to that and have the club and be able to go to the legislature and say, there's a change. And you have the Democrats on the hook now. If they wind up, and if you look at this, it'll be tough over the course of the next 5 elections for the Republicans to hold this. It's a lot tougher for whoever comes out of this concocted dual conference to flip on you the way Malcolm Smith did and say, I'll gerrymander them into oblivion, which was a huge mistake on Malcolm's part when he said that. With that, I'll stop, and I apologize for going over.
Thank you. So you said you weren't going to tell us, but I'm sure I know. what your recommendation would be in this respect. Maybe we'll talk about that when we
Sir
get
Thomas
into this.
More said, although it didn't save his head, silence is assent under the law.
Silence implies consent. Yes, that's right. But we knew what he thought. Jerry mentions a very important point, and it's something that we've been dealing with in different levels for some time about our Constitution. It's a larger point, so I just want to raise it for 1 minute here. We have an idea, Chris and I, about putting something together called the Constitution as Potemkin Village. Because in a number of ways, two of which were pointed out here, both in the Judiciary article, this Constitution, as it's written, the words, bear little relationship to what we do in New York. And you can do it in gambling, you can do it in a number of areas with regard to the debt limitations, with regard to the referendum. In all of these areas, there's a disjunct, a radical one, between what the Constitution says and what we do. So the question is, what do you do with a situation like that? Do you just learn to live with it? And everybody, like the Italians, pardon me from my patrons, you know, they understand the nature of reality and we just live with these things. Or do you do something about it? And so we think about there are a whole series of sections of this article which could be analyzed from that perspective and put together and called the New York Constitution as Potemkin Village. It might alert, we put this all together and alert people to the great gap between what we do and what we say. But that was one point that came out of here. The other thing is, obviously, what we need to do, and we're going to be doing it here for the rest of the day, I suppose, is some of these questions can be answered by simply saying, look, can we agree on what we want in the Constitution? This doesn't answer all the questions, but we can say there's certain things that ought to do, and you go from there. So all the other questions simply fall into place. I mean, if you say, for example, that the Constitution ought to provide the fundamental values and goals which we aspire to as a community, then, or the things that will sustain us, then you would put things in there like education. You would have a militia, at least historically understood. You would have rights. If you wanted to limit the Constitution, you would have limits in there. If you wanted to determine the organization of government, you would have structures organizing the government. So if these are the general things, if you start from there, you can pretty much go into the question of, well, does a gambling amendment belong in there? Is a gambling one of those things that sustains or creates the conditions for Republican government? Our forefathers and the state believe that in terms of morality and the need for morality to say, whether we believe it anymore, they believe that. It was there because it sustained, assumed, those civic virtues which were important to a republic. Whether that is true now, whether it's certainly not true in terms of what we do, it was, you can see how something like that might be argued for. So they're the kind of things we might think about as we respond to these, the questions about whether these things belong in the Constitution or not. And with that, I'll open the floor to questions and, of course, any comments from the panelists. Yes?
I have a question for Bob. You nicely outlined the exceptions and how the exceptions defeat the rule in the Constitution. But on the gaming issue, how will it play out in the legislature and, if passed in the legislature, among the electorate? If you could draw for us a scenario about how the different forces will be at play there, I'd appreciate it. Thank you.
Again, I'm not quite sure I know what you're asking me to comment on.
I asked you to predict the future on that.
That's what I was afraid of. I don't know. I mean, certainly there's going to be a lot of money assuming it gets through the legislature and it goes to the voters, there's going to be a lot of money on the campaign. You're going to have certain gaming interests that see opportunity. You're going to see other gaming interests from nearby states that see financial ruin if you have casinos in New York. And you also have the Indian interest who really have no interest in seeing more competition in the states. So it's going to be, I think it's going to be a huge, huge campaign, and it's hard to predict how it's going to come out. It's just, there's so many different interests. But, you know, we have there's a lot of gambling in surrounding states now. We have, you know, Connecticut, New Jersey, Pennsylvania, Massachusetts about to come on board, and certainly their interest is in drawing in New Yorkers. They don't want to see New Yorkers staying in the state and gambling there. So I think it's going to be a very active campaign.
Can I come?
Yes, and then Ellen and Jerry.
Let me say that I think there's first of all, very good chance of passage in the legislature on second passage. I think that it's brilliant to name 7 possibilities and not name what they are, because it gives the obvious claimants expectation. For example, Ulster County is here in the room, but in the Hudson Valley, we have long debated whether in Sullivan County there should be a casino, and the various times this has been tried, certain locations have been named. Interesting, one of them was Rockaway, which becomes interesting in the current environment, although the urban location seems to have been, the city location seems to have been elsewhere in Queens. So first of all, you have the nature of the amendment being politically, I think, very smart. And I don't know, Bill, if you want me to mention this, but Bill has a really interesting idea about potential linkage of campaign finance reform with the revenue stream that's generated, which, if that was done, would bring reformers into in a very substantial way. I don't want to steal his thunder, but let me make a few other points. Second, we know that there'll be a $2 billion deficit. That is, the executive has suggested there'll be a $1 billion deficit going into the economic impact of the storm. Now we know there'll be a $2 billion deficit. As recently as yesterday, the deficit's been predicted to be $3 billion. The comptroller is giving numbers. The budget division is not yet giving numbers. So the financial argument becomes more compelling. So you have a well-crafted amendment that's politically well-crafted. You have a compelling financial argument. You have a commitment to no tax increase, which the governor has made in the entering into the budget process. You have the potential for leadership of by a very popular governor on the pragmatic argument that the resources are needed, and as has been pointed out, everybody else is doing it. In other words, if we don't do it, the resources flow out of New York. If we do it, they're constrained in New York. On the downside, you have the existing interests wanting to resist change and even potentially litigating on the argument that certain agreements made with them are being violated about market areas and so on. So that has to be that. There's a sensitivity there that has to be acknowledged, but we haven't committed to locating these facilities anywhere, which is fundamental. So you have leadership, you have financial need, you have a well-crafted amendment. We don't know the composition of the Senate. I think the Assembly is committed on this, and there's no reason to think they won't remain committed. And I don't see, and on the other side, I don't see very serious mobilization. And I don't see serious resources. So I see the serious resources on one side rather than the other. And I see the I see the value environment of the state fundamentally, if not welcoming, not hostile, which may have been different in the 60s, for example, or at other times. So my colleague is unwilling to predict, but I'm willing to predict, and the reason is that I'm tenured. So if I'm wrong, if I predict, I get into the papers. If I don't predict, I don't. But that's my analysis. So and I have no personal. I have no dog in the fight, but I'm not certainly against the idea. Bill, do you want?
Okay, then Alan, and then we'll get to you.
First of all, Bruce, I thought you were brilliant, absolutely, and I am now convinced that we should give the governor a chance for redemption. And because I'm not a militant, and you have to respect the legislative leaders, and I am for a strong Republican Party. Now, Jerry opened up something that I'll describe briefly that we will go public with in the months ahead. It's been discussed with Creeland, Swartz, and Duffy. There's a lot of concern about public campaign finance reform. I share that concern. I'm all for the New York City model. I would support it. However, in these economic times, we have to respect that many people disagree with it. Or you could take the position campaign finance reforms time has passed because of the independent expenditures. But what I'm going to suggest, if you read the 17 words in the constitutional amendment on gambling, it doesn't say anything where the revenue goes, unlike the lottery, where it's devoted to education. There are two streams of revenue. One is the year-to-year license, and then you bet $100 and you give 90 back, and there's 10 left is the split with the state. There's no definition. So what we're going to suggest, in my words, to box the governor in, but I guess that's not very nice, we don't want to be able to say, well, we can't get money out of politics because of the public financing aspect. Someone like Brian Kolb, who will articulate that very well, and I have a lot of respect for his position. So we're saying take the small revenue stream, the yearly license. Let's say it's $8 million a year for a license. That's $56 million a year. It's $250 million over 4 years from these billion-dollar corporate giants. Use that to get money out of politics. Do the 6-to-1 New York City. Sort of fitting we take it from Getting and Edelson's companies. And then the big money, which is the split, you devote to education like we did with the lottery. It's an alternative. In my case, I think it's better, but I respect the public finance people, but we want to put two options before the legislature and say to the governor and the legislators, there is other alternative revenue streams. It's time to do enough. And Jerry and I have been working on this a long time, and it will go public at some point during the session.
Thank you.
Yes, Ellen, you had a question.
Hi, I'm Elena Sassauer. I'm director and co-founder of a nonpartisan nonprofit citizens organization called Center for Judicial Accountability. I thought this was a fascinating and important discussion. But there is a threshold question that I have that really, it came to mind initially when Mr. Rifkin began to speak so powerfully on Article 6, the New York State Constitution, which was when you were speaking about the amendment that has gotten first passage to raise the age of mandatory retirement. And I thought to myself, from whence would that amendment come? Who would push such an amendment? There are so many things in the judiciary article needing to be changed radically, dramatically. Why this one? Where does it come from? And obviously, it would only come from the judges, from the judiciary, from the Bar Association, with which you are now associated, coming out of a career in government. And then I was struck, I remembered what Mr. Samuel said, that it was the governor who proposed the amendment that has gotten first passage having to do with redistricting. Am I correct in my recollection? And then when Mr. Jory began to speak on, no, I'm sorry, it was Mr. Batson on the casino amendment, and I think you slipped in that it was the governor who had put forward the amendment. In other words, these amendments, this first passage, doesn't reflect any kind of democratic, representative people, democratic process. No, it's top down. It's insiders who have secured first passage. Since they control the show, they're going to obtain second passage if that's where the interests lie. And as to the voters, well, let's get real. When was the last time? I mean, year in, year out, we go to the polls and we see the ballot questions. Most of them, I mean, for myself, many of them I'm looking at for the first time when I'm in the booth. And I'm not aware of any articles written, any discussion about them. To the extent there's anything, it's top down from the editorial boards telling me how I should vote, but not giving me the real exchange and dialogue and understanding. So there's something very seriously awry, I would suggest. And I would take this opportunity to, although I am very critical, for a good reason, of the Brennan Center, and can attest to its lack of integrity and honesty when it comes to issues relating to judicial corruption and the corruption of the processes of judicial selection and discipline, which is what I've been doing for the past 20 years. But they have done some stellar work, reports on our dysfunctional legislature and how the committee system, for example, doesn't at all function, and that legislation is supposed to emanate first from committee hearings. Now, it seems to me...
You have a point you want to make because...
My question is, since legislation, I mean, bills that don't amend the Constitution are supposed to begin with hearings where there is an exchange and scholars and the public weighing in before the legislation is crafted, which doesn't take place in Albany, what is the process by which amendments are supposed to...
So you're suggesting that we haven't focused enough on where these amendments arose. They didn't arise in the legislature, and you think that's where they belong.
They're illegitimate.
Okay.
They should be the subject. First hearings, the legislation that results in the first passage should be the product of committee hearings. Scholars come forward, members of the public come forward.
So you have a general problem with the legislature and its committee system, and I think did anyone respond to that? Because I think it's a fair point about how these things get started from the bottom or the top in the public.
It's scary.
I'm not saying your view is wrong, but your view is extra constitutional. We are not an initiative and referendum state. If I deduce what you're arguing, it should be we should follow the model of California and have the ability for citizens to put referenda through the petition process on the ballot. That is an entirely legitimate viewpoint. It can be debated, but that's not the system we have now. And there's no provision in the Constitution that I'm aware of or legislative rules for hearings. We have a different system in the Congress. I'm not saying you're wrong. I'm just saying that's not the system we have. I'm not taking a position on it.
All right. We had a question. Did you want to?
I just wanted to add to the analysis
take that,
Dr. Benjamin was doing, where you sort of said there wasn't really any opposition that was funded or
I haven't seen organized.
You haven't seen it, right. I think you ought to at least add to the list that there will be some religious concern, and it's abroad in the land and not heavily focused, but it always is there. It's a moral issue for them. And the other one would be public health, because you do have public health people who are saying that addiction gambling is an addiction and it's not good for the body politic and the society at large. So those folks, although maybe not well focused, those interests are there. And it is a public interest issue, so they don't easily come to the fore, but it's buried.
I think that's very fair. That's very fair. Those points are very fair.
Question, was there one another? Oh, Tom, over here. Tom.
Hi, I'm Tom Gaze, the director of the Rockefeller Institute. I just want to, because people have been talking about campaign finance issues, I just wanted to have a brief announcement. On Monday, 1 to 3, I believe, we have a wonderful cast of characters to talk about campaign finance issues. December 3rd, Kostas Panagopoulos, Adam Skaggs, Michael Malbin, Jeff Stonecash, Syracuse University, as well as Barbara Bartoletti. So I hope to see many of you on Monday afternoon. Thank you.
I want to add something to this gambling part. This is really a troubling issue for me, not because of any religious sensibility, but if a constitution is to have those values embodied in it, which both pronounce and sustain the things that are important for a republic to survive in, like morality and education, and things of this sort, then how do you deal with this question of gambling when it seems, however, the positives are clearly there, how do you deal with this issue which, while it will give us more revenue, almost certainly will not contribute to those values, whether you're religiously based opposed to this or not? This seems to be why it's difficult to determine. Does gambling belong in the Constitution? Well, at one level, it's pretty obvious. What is this doing? It's a policy issue. But at another level, it's why the model state Constitution, in spite of the fact it says get all these policies out of the Constitution, had education right at the center and public finance at the center. Because there are some things that we think too important and too crucial for the maintenance of the republic to leave to statutory legislation. This is the troubling aspect of the gambling for me.
And not to mention that you have a general prohibition that is currently existing that you're trying to get around. I don't mean you, but the people who are advocates, and we already have these exemptions that, the lottery is functionally is already an exemption. You have the example of the Indians. So, I mean, if the prohibition were not there, I doubt people would be proposing a constitutional amendment. They'd prefer to keep control on legislation that they could change.
Yeah. You see, I think without necessarily realizing it, we've sort of passed the question of whether or not we should have gaming in New York. The reality is we do in so many different ways, as Bob pointed out, with the lottery, with pari-mutuel racing, with the racinos, with the Indian casinos. So to the extent there's been this debate over whether or not gaming is good or bad for the body politic, that debate is over and done with. And now what we're really talking about is the types of gambling we should have and how much gambling we should have.
The battle is lost, but it's not.
That battle's been lost.
But that has nothing to do with whether or not this is the kind of thing that might have been or should be in the Constitution. Now we've compromised, we made it a potential
and now whether or not whether or not to have gambling is a fundamental policy that belongs in the Constitution. Maybe it does and maybe it doesn't. That's not what this amendment is all about, whether or not there should be gaming in New York State. There is gaming all over New York State, and this is simply about how much gaming we will have in New York State.
Too late.
And it's not a big policy question, it's just the extent of gaming that we're going to permit.
Terry?
Mr. Rifkin, we're not previously acquainted. I very much enjoyed your remarks.
Good.
I'm completely confused about the politics of judicial elections, which you didn't mention. My friend Michael Kavanaugh is approaching the age of 70, and because his term came to an end, needed to seek re-election and failed of re-election.
Well, he unfortunately lost.
Yeah, and so he was elected in Ulster County before it became a Democrat venue. He was a DA in Ulster County as a Republican.
He was a DA of Ulster County.
So my understanding was the Democrats were approached and said, I'm 68. At 70, I will be required to. I think he would be required to retire. Would he not?
No, he could get certified.
He gets certified at 70. Yeah. So there's
while he's on the appellate division is an arm of the Supreme Court. So appellate division judges can get certified.
Okay, so he promises that I, on a stack of Bibles, I'll get myself certified, open the seat. You can have the seat when I'm 70. Just cross-endorse me. Another pathology of New York politics. And they said, nah, we can beat you now. Goodbye. So here we have two. I think extraordinarily good judges in the district. There was another fellow from
Bud Malone,
and
we lost Tony Carbonello the prior year.
Right, who was also
all three are excellent.
Also a person I thought was good. I'm not expert at this, but doesn't that suggest to you that we need some other way of doing this? I mean, it's the nature of the it's not only. It's the nature of the politics that is involved, as well as the number of other issues you talked about.
Well, let me say that I personally throughout my professional career, have been working with bar associations and other groups to support merit selection of judges and get rid of the concept of election of judges. The election of judges makes no sense for a whole batch of reasons, including the fact that we lose good judges for no good reason, because the populace has no sense of who's a good judge and who is not a good judge.
Richard, if you take that position...
And by the way, our bar association, state bar association, supports merit selection of judges.
If you take that position, what it puzzles me about the history of New York, talk about our traditions, is it is the issue that almost certainly will lose if you put it before the elected. The electorate in New York somehow does not want to relinquish electing these judges. It's from 1869 on. I mean, we've had this problem. So is there something pathological about that, or is there something else going on here?
Well, I mean, you can say it's pathological, but in part, remember, the county leaders have a real interest in maintaining election of judges. Bruce may disagree with me on this.
No,
but,
no.
But because now, first of all, Supreme Court judges, who are our fundamental trial and appellate court judges, are not elected at the general election. We have what we call judicial conventions, and if you're familiar with them, you'll understand how they work, and it's probably too complicated to explain this morning. But fundamentally, we have a system for choosing Supreme Court judges whereby the party leaders totally control who gets to be a judge. And what that does, of course, is the party leaders then have all the lawyers who are interested in becoming judges working for the party for many years with the ultimate hope that the time will come when they are anointed by the party leader to be a Supreme Court judge. So it gives the party leaders, number one, the sort of a power to get people to work in the party because they're interested in becoming a judge, and some of them will work in the party for 10, 20 years, with that being the ultimate objective. And secondly, it gives them the actual power to designate who's going to be a Supreme Court judge.
Not only don't I disagree, I totally agree, and I would disagree slightly with Peter. I think now in this day and age, I think if you had a merit selection referendum on the ballot, I haven't thought it through, but my back of the envelope calculation is I think it would pass. But what you're going against is, in a time when patronage, if you compare the amount of patronage that a county chairman had at his or her disposal, and too few hers exist, but at his or her disposal, now versus 50 years ago, that has all been winnowed down and boiled away. And the last bastion of patronage for high-paying jobs is the judiciary, meaning the judges, their law clerks, other people in the courts, and what you have is the county chairs will fight you tooth and if you think the legislature will fight you hard on redistricting, the county chairs will fight you hard there. But I think if it were put up to a referendum, you would have a decent shot. It's the insider game you're going to lose at that on.
Yeah, on a referendum, my sense is that there'd be an upstate-downstate split. I think you could be fairly successful downstate in selling this. I'm not so sure about upstate.
I wonder what the split was. Remember, the last time we did this, the one time I think we did move from elections was with the Court of Appeals in 1977, a major court reform. I don't know what the split was. I remember now on that in terms of upstate, downstate.
Well, but that was really driven by the perception that, God rest his soul, Jacob Fuchsberg had nearly bought the chief judgeship of the Court of Appeals against Charles Breitel, so the entire inside establishment rebelled against it.
Yeah, and that amendment had the real leadership of Governor Carey. You know, you had a governor who was taking a real lead on that.
You sure I'm wrong on that?
What?
Oh, you're right on that, Bruce.
No, they're telling me it was Jack Weinstein.
No,
it was Fuchsberg.
It was Fuchsberg, absolutely. What?
But
the primary was against Weinstein, but it was the fact that Fuchsberg nearly became the chief judge that got everybody upset.
They didn't want that. Did you have one question?
I was not wrong. Thank you, Richard.
I do indeed. You made...
Professor Galey, you made an excellent suggestion. Which
well, you know how to get me on your side, don't you?
No.
It wasn't that good.
You said something to the effect of there should be careful scholarship as to the proposition that our Constitution, our state Constitution, is a Potemkin village. It is a Potemkin village, but that includes because of what the judiciary has done by decision after decision after decision, because all these years there have been citizens in the trenches who have engaged in self-help, trying to achieve good government by going to court. And what has happened to their meritorious challenges is that they have been turned away by decisions which are judicial frauds.
Well, would you have a recommendation, for example, would you like an amendment to the Constitution to do what? That would be a good suggestion.
What I'm saying is, because it was stated here, this one is a good judge, and that one is a good judge, but what is your evidentiary basis?
Well,
Have you
what
examined
recommendation
the
would you make,
decisions?
Elaine? It would be helpful to give us an idea what you would like us to do.
In short, there needs to be involvement of citizens to give you chapter and verse as to what quote, merit selection looks like. If you're speculating about how the public would vote, maybe you should get the public in on why they would not prefer merit selection, and maybe you should, in conjunction with that, do an expose as to why there is no research in this state on the reality of merit selection 35 years after we gave up election to our state's highest court, the Court of Appeals. There hasn't been not a single scholarly research examination of how that merit selection process has played out, and for years we have been documenting how corrupt
I know that's your interest. Thank you. Well, one question? Yeah.
Question to Dick. And maybe I could figure it out, but I'd rather you tell me. Why do you think the referendum
Yeah, you could probably figure it out better.
No, I don't know about that. Why would the referendum lose upstate, do you think?
Which referendum?
On merit selection.
Because, at least from what the political dynamic that I've seen, is that the people upstate, first of all, downstate, you don't have the kinds of elections you do for judges. Fundamentally, the one-party districts, so it's all controlled. Upstate, you actually do have districts, such as the 3rd District, which is now, you have competitive elections, and somehow people upstate believe that it's a good thing to have competitive elections. And of course, elections, when they're competitive, generate much more interest. So I think that's why you have that difference.
There's another question. Yes, back there, please.
Hi, my name is Bob McAvoy, and I am a member of the 4th Judicial District Independent Judicial Qualifications Commission. And in honor of our great Judge Kay, I'd like to just bring this point up, a quick one, is that Jerry needs to do some research on this, and I know it'll be done well, to the great success of this process. I spent a lot of time on it, and it's just absolutely wonderful. And it is a political compromise between professional selection of judges and election, and it works really wonderfully. And I've been through many of these issues, through many of these sessions, and I'd like to have that added to this discussion.
Second that proposal.
I think I think we're just about right on time here. So, do you have one quick question? One final one right here.
John Clarkson, former state government policy person, currently a town supervisor. This isn't directly on point of what you discussed, but I figure one of you might know. The public pension system in New York State, both local and state, is covered by the Constitution, including a provision that says pension benefits once offered may not be diminished or taken away or something. I've heard this only as an anecdote, but I had always understood that that meant you couldn't change anything about the system, including the contributions that public employees previously made. When I started, there was a 3% contribution. We've changed that over the years legislatively within the Constitution, but we've changed it only prospectively. So once, for example, the 3% was eliminated, it was kind of accepted as an urban legend that you could never restore it because the Constitution would prohibit that. And all of the change has been executed by adding new tiers onto the pension system. Now, I've heard lately that may not be true, and that actually, if you interpret that provision about not changing pension benefits once offered, you could interpret that as only meaning the pension payments once someone retires, not what someone pays during the term of their employment. This is tremendously important as a government cost issue, and it's an issue of some public significance. The major reform that New York State has offered to cut the cost of the pension system is Tier 6, which only affects new employees. Now, both for the state and local governments, for example, in the town of Bethlehem, we're not hiring any new employees, and if we do hire one or two, there's a high probability they'll already be in the system. So that major reform to help local government costs doesn't help us one iota. On the other hand, if instead the state would turn to, all right, let's restore at least the 3% contribution for the mass of employees still working, that would have a tremendous and current impact and would save both us and the state government some money. It would, moreover, be fair as well. It's not unrealistic to ask employees to pay a minor amount for a very good pension system.
So your question, is that possible?
My question is, do any of you know, do you have a view on this? Have you heard? Is this true?
It is accepted, although I'll defer to Richard in all things legal, but it's accepted that prohibition in the Constitution on changing pensions is the broader interpretation. That is being challenged. Similar state constitutions that have that are being challenged in other jurisdictions. So we don't really know. Most lawyers think, or the conventional wisdom, which could be changed, is that will hold, and from your perspective, you're you-know-what out of luck. But you raise a larger question, which is the three key constituencies that are terrified of a constitutional convention, which Jerry has outlined before, are in fact the public sector labor unions because of that, the environmentalists because they're afraid that the Adirondack provisions could be changed, and the third were the winners of the CFE lawsuit, the education advocates. They wouldn't want to open the door to games being played with that. Now, I'm not saying that's a reason not to have a constitutional convention, but I'm suggesting that those three key constituencies are why, when that comes up for an election, the people advocating Jerry's side and former Governor Mario Cuomo's side of that, saying we should have a constitutional convention, run up against some institutional opposition. Would you say that's fair, Jerry?
On that note, I think people want to take maybe a little break before the next session, so thank you very much.